Hello again, and for the last time in the year 2021, this is John Miller, founding attorney of Rock Solid Law and Title, now in Ponte Vedra Beach, serving Northeast Florida. Thank you so much for joining us. We've got an interesting, if not, in my opinion, overly exciting presentation this morning. John, why would you talk about that? Well, those of you that have heard me speak know that I consider estate planning to be more about the planning, the exploration, the values, the figuring out the future of the family. Today's is rather nuts and bolts. We are going to make sure that you have a good basis of understanding of the documents used in a basic estate plan. Hey, I got to throw it out one more time because here we are in December. 2021 has been celebrating the 30th anniversary of the founding of my law firm. So Rock Solid Law is experiencing its best year ever. And thanks to those of you that have been ongoing referral partners. I see a few on the call or the video, and additionally clients. Really appreciate you. Love what we do for this community. Anybody that's new to the call, we only do three things. We close real estate, both commercial and residential, professionally and on time. We serve small business owners from inception of the entity and planning the entity all the way through transition planning. And we help serve the American Floridian family through estate planning, which I say we're the real family lawyers. I think it ought to be just called divorce law and not family law, but they co-opted that name a while ago. Our role, as I see it in estate planning, is to make your family strong, keep your family strong in your generation and for generations to come. So as promised, today is going to be a little bit nuts and boltsy, not what really floats my boat to talk about, but very, very important that people have an understanding of it. And I know I'm a 38-year lawyer now. We lawyers love to speak, lawyers speak, right? And so one of my missions with Rock Solid is to not do that, to try to bring the education to you in words that you understand with as little Latin as possible. So we're going to go through, I called it the 6 important documents that are included in most plans. You know, every plan's different. But these are the ones that we really think are important. And there may be, as usual, a bonus document or two thrown in. One, we're going to talk about first the documents that take care of you during your lifetime, because estate planning is first and foremost about you. We want to avoid you ever having to go before a judge when you are incompetent and to have a guardianship action, because that's basically having probate done while you're still alive. Someday, if you hear my sort of stump speech, you'll hear the story about Groucho Marx, who was unbelievably wealthy but couldn't be bothered to do an estate plan and ended up having to watch his own guardianship, where people fought over basically his fortune during his lifetime. Then, of course, he died shortly thereafter and had to be done all over again. So how do we avoid that? Durable power of attorney is the first document. So you want to pick somebody who would be in charge of your affairs, basically your business affairs, your personal business affairs. What does that mean? Your checking, your insurance, your mortgage, your utilities, all of those things that you consistently do in your everyday wanderings. Other people are not legally entitled to do for you, even sometimes your family, for instance, a bank account that you are on only by yourself. So we at Point, we execute a durable, sometimes family, sometimes power of attorney all the time. And that power of attorney is going to allow someone to step in for you when you can't. It could be during a temporary incompetency, like maybe you're in surgery, or it can also be long-term once you're no longer capable or have legal capacity to handle your own affairs. Now, a couple of points about it. First, The fiduciary that you appoint is called an attorney in fact. It does not have to be an attorney at law. Notice the at law and in fact are two different terms. So this is just a person that you trust. It could be a professional. Most often it's a spouse or family member, sometimes a trusted friend or professional. Interestingly, 10 years ago, Florida completely revised its power of attorney law. So if you have or you know someone that has one that is over 10 years old, they need to be updated. They will be grandfathered, but there are all sorts of now legal problems with ones that are created before 2011. So there's a first freebie pointer, and like this document, every one I'm going to talk about. If you need it reviewed, let us know. We'll take a look at it. If you're in good shape, we'll let you know. No charge. If you need a revision, we'll let you know. If you want to work with us, that's awesome. If you want to work with somebody else, that's actually okay too. It's your choice what lawyer you work with. So the couple of things that changed big time 10 years ago, just so you know, prior to that time, under Florida law, a power of attorney could spring to life when needed. We call that a springing power. What does that mean, John? Well, it means that the document was there, but it wasn't actually in effect until the person became incompetent. Well, as you can guess, there's all sorts of litigation about, I was not incompetent, was to, was not, and somebody took an action in somebody else's name, which they didn't like. The banks and other institutions had a real hard time knowing when to rely on a power of attorney. So the springing power was taken away. The unfortunate side effect of that is that now the moment a power of attorney is signed, it is effective. So it's really important that your fiduciary be someone you trust that won't take that instrument, run out there in the great big wide world and do things in your name. So obviously, there is a real safekeeping issue with powers of attorney now. And that's something that you will want to be cognizant of as you have one in effect. The second thing that was changed, major thing that was changed in 2011, was we are no longer able to give broad, sweeping general powers in the power of attorney. Therefore, it has become a large and, in my opinion, unwieldy document, multi-pages, always better than a will, bigger, not better. It's almost always bigger than a will. And it's sometimes even bigger than a trust. So it is now a large document that requires multiple initials because you have to grant each of those powers specifically these days. All right. I went ahead and did number one as power of attorney because it required a little extra discussion. There are intricacies to that one that you'll need to want to understand as you do your estate plan. Second, oh, by the way, as people are moving to Florida and bringing their estate plan with them, they need to have them updated to Florida law if this is going to be their residency now. And especially we encourage people to get their power of attorney updated because you wouldn't want to have an ineffective one from another state. Let's move on to number two. Much simpler, much simpler. Designation for healthcare surrogate. So the designation for healthcare surrogate is also a power of attorney. Again, you're appointing a fiduciary who is technically termed as an attorney in fact. But this particular power of attorney is only for healthcare issues. So now, rather than picking somebody who is good at managing financial affairs, you are wanting to choose someone who cares about you, who has your best interest at heart, and who is capable of interacting with your physicians, your nursing staff, your hospital administration, with all of those things that go on with the delivery of healthcare in Florida or America these days. So it's a pretty broad based fiduciary position, a pretty serious obligation. Again, in this one, we typically see the spouse appointed first and often an adult child next or a very close relative or family friend. So that is called the designation of healthcare surrogate. Third document that I'd like to talk to you about is typically the worst named document in all estate planning. It is very confusing. It is called the living will. A living will is not, I repeat, not a last will and testament. If you are in the estate planning field, obviously on a day-to-day basis, you are considering death. Fortunately, I was raised by wonderful parents and have a strong faith, and I don't have issues with talking about death. But I've noticed that most of the American population does. In fact, 80% have either no or an outdated estate plan. 80, Dave Ramsey says, percent. It's certainly over 50%. And my hypothesis is because in doing so, people have to acknowledge the fact that someday they're going to die. Pretty much, as Jim Morrison titled the book, No One Gets Out Alive, right? So we all have to be realists about this and plan for what's best for those we love when we're gone, right? And so what is the living will? It's really for when you are going. It is the document that is effective during your last or anticipated last illness. It talks about the kind of treatment that you want to have and the kind of treatment you do not want administered to you at that point in time. Therefore, our office and many other practitioners that I think are a little more enlightened call it a directive to physician. You are not appointing a person to make the, as the saying goes, decision to pull the plug. You are directing your physician exactly how you wish to be cared for and at what point you want that care to be terminated. You understand physicians are under the Hippocratic Oath, and therefore they are trying to maintain life. Well, we've developed to a point where it is possible to completely artificially maintain life on a carbon-based body that no longer has any brain waves, is not going to future have a functioning brain, and can also maybe not even have a functioning heart, but it's being kept alive only by mechanical means. A lot of people don't want to be in that situation. We in Florida, those of us that are older, remember the Kieran Ann Quinlan case, which really developed the practice in this area because her spouse and her parents disagreed on whether her comatose body should be kept alive. I've actually taken a couple of continuing legal education seminars, not on that subject, but from the attorney who was involved in the case at multiple levels, state and federal, on appeal, et cetera. And none of that need occur ever again if people just express their wishes to their physician, who must have the opinion of a concurring physician in order to make the decision not to administer additional treatment. I often use the example, if a person is already terminal, right, in this condition without reaction from the brain, is being kept alive by breathing apparatus or other apparatus like heart apparatus, and a cancer is then discovered in addition to the existing condition, you might not want to have chemo and radiation started at that point in time. In fact, I would say that in a 30+ year estate planning practice, we're close to 100% that people want to check that box. Don't do that to me at that point in time. And candidly, we're doing estate planning. We're trying to pass the wealth from one generation to the next. And the last hospitalization, it has been said, is as expensive as the previous 40 years of treatment in many instances. So if you prolong that last hospitalization, it is possible, unless there is excellent health care in effect, that the wealth that your heirs would receive will go to the hospital instead. So this is called by some a living will. The better name is a directive to physician, where you direct your physician on how to treat you. All right, let's move on to number 4. That's, as I just indicated, the last will and testament, which is different from a living will. Little joke, people contact me and say, I need a living will. I go, why, are you dying? So there's only people I know well already. What they really are thinking of is the last will and testament. because they didn't take a class like the one I'm giving you right now. So the last will and testament is a document in which you state what your wishes are for the delivery of whatever part of your estate you don't use to whomever, to who you love or what you love. Could be a charity, could be anything. A will is an excellent document for determining where wealth should go after a person is finished with it. Unfortunately, in Florida, people who have only a last will and testament will all go before the probate judge. Candidly, we have excellent probate judges here in Northeast Florida, always have in my practice. But the probate process is expensive. It is time consuming. There's no way you're going to be in and out in less than 6 months in almost every case. And if there's any dispute, it'll be years, probably at least 3. And in my long-term experience, check out the wrinkles, check out the gray. I've been there, done that. Probate is where families go to fight. It is where that one person brings up the ridiculous argument. And candidly, my phrase is it burns down the family tree. I know people that will never speak again, siblings that disagreed. Even though it seemed like mom, dad, uncle, aunt, whoever it is, laid out in the will what they wanted, people will come up with theories that that's not what they really meant. They'll argue about the competence. There's multiple levels of arguments available, and there are many, many litigators out there that are all too happy to take the family's money to go have a fight down at the courthouse. We don't believe in that. We will create a simple will-based package with the building block being the last will and testament for the right family. Typically, a family who has at least $300,000 in assets, we want to begin to look at the possibility of a plan beyond a last will, which I'm going to discuss in a minute. Certainly at $500,000, there has to be a good reason not to do it. And when you get $750,000, $1 million and up, you really want the will to only be a small part of the plan that you're doing, and basically a safety net to the trust package that you create. So real quick, what is the safety net? What did I just say? And I'm going to go to basic level trust as the next document, but in a package which includes planning beyond a last will and testament, we'll have what is known as a pour over will. The pour over will is the safety net. You can think of it as under the high wire aerialists at the circus in case they fall. In case something falls out of the estate that wasn't properly titled in the trust, you will have the ability to go to court, and the pour over will very simply retitle those assets into the trust so that they can be distributed according to the terms of the trust. Okay, so for folks that have not amassed a lot of material possessions, a last will and testament may be the way to go. So the next document I'd like to talk about, and the only trust document I'm going to talk about today, is the revocable living trust. The fancy term is inter vivos, which is Latin for during your life. I had a law school classmate, brilliant lawyer, working for a corporation in England now, who used to say that we lawyers like to sprinkle Latin like so much salt on a meal. So you can guess my distaste for that, although I love the Latin terms as well, and took a couple of years of it in high school. So the revocable living trust is an instrument that first and foremost keeps your family out of court. We've completely eliminated the judge who was appointed by a politician from being in charge of the distribution of your estate when we use a revocable trust. The only document filed with the government is a notice of trust, which just gives notice to the world that there is a trust, and therefore there's in all likelihood not going to be a probate. There will be a probate if you didn't fund your trust, which means transfer the title to your assets into the trust. And I'd just like to go on a little side tangent and tell you that every trust package that is created by my firm and that you work with our firm to do will be properly funded. We're going to help you retitle those assets into the trust. I believe it borders on malpractice. The attorneys who merely hand the client a sheet of paper instructing them what to do. Because in my long-term experience, it's another thing people procrastinate about exceptionally well, and therefore basically never gets done. Okay, so once the trust is created, the end of the interaction with the firm at that point in time will be to make sure all the titles to all the appropriate documents are put into your trust. Okay? Even with our help, people procrastinate really, really well. So the revocable living trust document is the distribution document. You will say how you want your estate distributed. And a beauty of it is it can continue to control that distribution for a significant period of time into the future after you've died. So if you have minor children, if you don't want your children to inherit at 18 or 21 or 25 or 30 even, you can create a plan where your trustee doles out the money in the way that you have said. Now, often discretion will be given for health, education, welfare, maybe a pot of money after graduation, maybe one in their 20s for an entrepreneurial pursuit or a down payment on a first home, whatever. Our firm is agnostic as to what your values are. We just want to know what they are so that we can incorporate them into the terms of your trust and make sure that your plan suits those people that you care about most. So that initial level of trust is called the revocable living trust. For living trust is fine. It's a living trust. During your lifetime, you maintain complete control of all of your assets, right? In order to get asset protection, you've got to relinquish some control. So this first level of revocable trust, you have complete control over. You can revoke it. You can change it. You can do whatever you want during your lifetime. An irrevocable trust may have an asset protection or a tax consequence, and those are beyond the scope of this discussion, except to say that there are multiple kinds of trusts. And smart lawyers are creating new strategies all the time, which incorporate new kinds of trust when there are changes in, especially the tax, gift, inheritance laws that mandate that people with significant wealth take action to eliminate, to thoroughly use the gift tax or thoroughly take advantage of the estate tax parameters. Number 6. It might have been a little cheesy for me to count this as number 6, but don't worry, I've got a bonus one. So I think I've given the number 6 significance in this webinar. And I know I'm running out of time. I always try to end by the half hour. Number 6 is a certificate of trust. Why would you do a certificate of trust? Well, that's the thing you can show to the world that the trust exists. For instance, when you open your account at the bank or your financial planner broker, and without having to disclose the whole trust. Why? Because what's in that trust is your business and nobody else's. All they need to know is that the trust exists, that it is in good standing, and the certificate of trust is the document, which is just a little 2 or 3 pager that you use for those purposes. So that is a certificate of trust. All right, I promised an extra document. I've already jumped ahead a little bit to trust funding, so I'll hit that. It's the first of 2 that I'm going to mention in just the next couple minutes. Bear with me. Trust funding is an, I think, awkward term. It means to put everything that you possess into the title of the trust. So retitling might be a better term. It's not the one people use. They use funding. So we use funding. So people always say, what is funding? Funding is simply, for instance, taking your checking account and retitling it into the name of your newly formed trust, or making the newly formed trust the payable on death for your retirement account. That way, all of the money that you leave behind, all of the things that you leave behind go to the trustee who has to follow the rules that you've created. And we can create almost any rules as long as they're not illegal. So that's what trust funding is. Lastly, I have found that a whole lot of people, and probably fair to say myself included, get serious about estate planning when they have children. And why? Because they want to make sure those children are cared for after they're not able to care for them, either by death or disability. You know, I am of the opinion that we will do significantly more for our children, for those that we love, than we will for ourselves. So I wanted to bring up, as a little bonus document beyond the six, the Declaration of Pre-Need Guardian. This is a standalone document which is going to say who it is that you've decided would take care of your kids if you were not able to do so. You know, obviously until they reach the age of majority. Then you'd want to have that trust in effect so the trustee can make the determination of how to share whatever you have left behind with those that you love. We call that showing your love those you treasure. I see I have run right up against the half-hour time limit. I hope that this is informative. These things, these nuts and bolts, are important. They're good to know. They will be part of the plan we create. They're really not the most important part. The part you really, I believe, should care about is, what are your values? Who is it you care about? How do you want to be cared for yourself through your lifetime? And who do you want to take care of when you're not here any longer? So if you would like to get together for being live and in attendance today, I am absolutely happy to offer each of you a 1-hour consultation with me or our other attorney, Kathy, if you prefer. And that is at no cost. I would ask that you make the appointment before the end of next week. Before the end of next week, just call and make the appointment. That's not saying that the appointment has to take place by the end of next week, because it probably won't, given our calendar. And it's fine if it's in the first part of next year. So wanted to offer you guys that. Thanks so much for joining. I'll also say that I have a document with the definitions we went over today, and actually some additional information for some higher level planning. If you're interested, email us at questions@rocksolidlaw, and our team will get that document out to you. It is just a nice, concise indication of each of the documents that you may consider, and some that were beyond our discussion this morning. And I want to say you are very welcome. I am glad it was understandable and informative. I strive for that. And I will follow up on that promise, and we will get that done. Looking forward to it. Guys, part of my childhood was spent in Tuskegee, Alabama, and that's where the Commodores are from. I wish I'd followed their old advice and bought Zoom stock at the beginning of this pandemic. I didn't, but I still enjoy playing their song at the end of every webinar. You guys have a happy holiday, a Merry Christmas, a beautiful season, and I'll talk to you soon, or I hope within the next month. Oh, you're so very welcome. You're so very welcome, Karen. Thank you.